Mr. Speaker, this bill is just another page from the majority's tired old playbook of inventing perceived gaps in the law and providing overbroad legislation to quote-unquote fix them. DUIs are a serious problem. Over 13,000 people died in alcohol-impaired driving traffic deaths in 2021, and all of those deaths were preventable. But instead of working on proven solutions like improving access to public transportation and ride-sharing programs so that people have alternatives to driving drunk, Republicans are laying the blame for the problem at the feet of immigrants. Now, let me be clear. No one here wants to see individuals who are true threats to public safety eligible for immigration benefits. But our immigration laws already exclude public safety threats from being able to get visas or legally remain in the country. Under our current laws, this includes those who have committed serious DUI offenses. Under the Immigration and Nationality Act, a non-citizen who is convicted of or admits to committing a crime involving moral turpitude, or a CIMT, is generally inadmissible. Likewise, a non-citizen who is convicted of a CIMT, where a sentence of 1 year or longer may be imposed, is deportable. There is substantial case law demonstrating that serious DUI offenses are considered CIMTs under current law. DUI, where the maximum possible penalty is a year or more, and where there is serious bodily harm, hit and runs, aggravated DUI, and a DUI involving driving with knowledge of an invalid, suspended, or revoked license are all CIMTs and are therefore already deportable offenses. This means that under current law, the people who are drinking and driving and putting people at risk of harm are already removable. But the majority is not satisfied with this. They want to deport everyone who has ever received any conviction for any DUI offense. Here's the problem with this approach. Every state has a different standard for how they define and prosecute DUIs. Some states will charge people with a DUI even if they are not actually driving a car. For example, prosecutors in Virginia convicted a man of DUI who was inebriated and asleep in the driver's seat of his car with the keys in the ignition so he could listen to music in his driveway. This case, in which the driver never even left his driveway or even turned his car all the way on, went all the way to the Virginia Supreme Court. We cannot rely on prosecutorial discretion in this type of case. Under current law, the man in this case would not ultimately be subject to removal based on this conviction if he was a non-citizen. But if this bill were to be enacted, such conviction would lead to the deportation of even a long-standing green card holder. If this bill fixed, and remember, we're talking here about long-standing green card holders, not illegal aliens, people who entered the country legally, who may have been here for 20 or 30 years, who have American citizen spouses and children. And if this bill were enacted, such a conviction of sleeping in your own car, inebriated, in your own driveway, going nowhere, would get you deported. If this bill fixed a serious gap in the law, I would be supportive. But this bill doesn't do that. It puts people who are here legally at risk of removal for making even a minor mistake that harmed no one. All at a time when our immigration courts have historic backlogs and Republicans are refusing to provide DHS with the resources it needs to enforce the laws currently on the books. This is purely for show, but I would expect nothing less from a party that has admitted they would rather wait to fix the problems in our immigration system so that President Trump can preserve the issue for his campaign than actually work towards meaningful reform now. I urge members to oppose this legislation, and I reserve the balance of my time.